and welcome again, everybody, to today's training, Triage and Expert Systems. Thanks so much for joining us today. We're delighted to have such a large group with us for this topic. Today's training will examine the growing use of triage and expert systems in legal aid contexts and how these kinds of tools can assist advocates, other service providers, as well as litigants themselves with a variety of processes. And on the next slide, you'll see we have a great panel to share their experience with this topic today. Joining us is Zach Hutchinson, who is a student and research assistant with Georgetown University Law Center. Zach is going to kick things off by talking about 3 triage and expert systems he's been involved with developing at Georgetown, the goal of those applications, and his experience and observations overall with the design process. And then my colleague Adam Friedl, Probono Net's Program and Special Initiatives Manager, will be joined by Donna Dougherty, who's the attorney in charge at JASA Legal Services for the Elderly in Queens, New York, to talk about a project that was originally developed via Georgetown in a partnership with a class there to help community workers perform legal health checkups for the homebound elderly. And then we'll wrap up today with Mark Lauritsen, who is the president of Capstone Practice Systems and whom many of you know from his deep involvement in the online document assembly community over the years. Mark is an attorney, an educator, and pioneer in the delivery of legal services using technology, and will discuss tools and design techniques to help users balance considerations and make better choices. So we have a lot of experience and brain power on our panel as well as among our attendees today. So as Jillian mentioned, we really encourage you all to use the chat box to ask questions, share your comments, observations, or your own ideas for how these tools and concepts might apply to service delivery needs in your own communities. We'll also pause in between each segment to kind of summarize and do Q&A with the panelists themselves. So for our takeaways today, we want to just define a little bit more what we mean by expert systems. So what are some examples of these online tools that help guide people through complex legal problems or situations, and how do they work? You've probably encountered some of these systems in your daily life, maybe even outside of your work environment without even knowing it, and these kinds of tools that are being increasingly used in government agencies or the private sector to help perform processes and calculations and help break down complex processes and make them easier to understand and act on. So we'll be looking at some examples that are in the community now to increase the capacity of organizations in aiding advocates in performing screening, triage, and legal analysis activities, helping litigants navigate and guide them through unfamiliar processes, and also helping to empower non-legal advocates to assist in screening and other activities to help identify legal needs or make effective referrals. So our goal here, as we'll see on the next slide, is to really highlight approaches that are accessible and replicable by the legal aid community as a whole. There are a spectrum of tools that are being used now to develop these kinds of systems, and our intent was to focus on approaches that don't require really deep programming experience or technical expertise to develop or maintain. So some of the tools you might hear about or you should be aware of include Neota Logic. Several of the projects that we'll talk about today use that. There's a rules engine called Drules that is being used very effectively in a statewide intake and triage system in Illinois. There are a number of successful examples of similar systems that have been developed using document automation tools like HotDocs or guided interviews using A2J Author. There are also Drupal-based tools that are being used in intake and triage contexts in Massachusetts and other states. And then more kind of simple formulaic systems like simple checklists can even be created using HTML or JavaScript. So if you're working with other tools or approaches or aware of other software out there or technology to do this, we would love to know. Let us know in the chat box and we'll compile those and try to share those with the group along with the materials after. So one note here on the next slide I wanted to mention today, our examples won't go into a great deal of depth on examples of triage as a front end to online intake. We've covered several really exciting projects in that space in a few other national webinars and workshops recently, and I've included links to those here. If you're interested in that dimension, we would encourage you to check these out. I'm happy to connect you with projects that are under development in that space to learn more. I also included here a link to the most recent round of grants awarded by the Legal Services Technology Initiative program, where there are some other kind of intake-oriented triage tools that are under development this year. So we hope we'll have a chance to highlight those projects again as they continue evolving in the coming months. So if you're interested in that dimension, particularly that 2013 NTAP training that was done late last year at the top of this list is online, and there's a recording of it, and I think represents some of the really exciting projects, particularly take-funded projects that are in the works in this space. So with that, we will go ahead and turn this over to Zach to kick things off with talking about several projects he's been involved with at the Georgetown University Law Center.
So hello everyone, my name is Zach Hutchinson. As mentioned earlier, I am a current student at Georgetown Law and have served as a research assistant for Professor Tamina Rothstein here at the Law Center. Tamina runs our programs on teaching expert systems, and she has a couple flavors of this class. One is for pro bono organizations. That's mostly what I'll be talking about today. Another one is for regulatory agencies. The way that it works is we have several students that work with a team that work with an actual client who needs an application. They tend to be triage applications. But and as you'll see with some of the demos that I'll show, they can really be any legal question or a practical problem that the organization may face. The general idea is to create an application that makes their process more efficient, whether that's helping a particular user with a problem, whether that's helping the organization internally, whether it's an advocacy piece trying to help make a complex area of law a little more simpler. We do all of that. And I think the most important thing is that none of our students have any kind of prior programming experience. We generally use Logic. I think there are some apps that have used basic HTML or JavaScript, and these are people who did have some prior programming knowledge. Some people use Access to Justice, but most of the ones that we use are Logic. And as mentioned earlier, there are an increasing number of applications out there that are designed for ease of use application building. As you can see here, these are one-semester classes for people that have no prior experience, and they're expected to have a working professional product by the end of it. If they can do it, I think any organization, any person representing any organization here could as well. Oops, why are we going backwards? There we go. So the thing that we find most informs the types of applications that we make categorically is who it's designed to help. And we have kind of three categories that I'll talk about and have examples for each. One is a self-help tool where users for a particular organization, whether that's low-income workers or people going before perhaps an appeal for a particular administrative or appellate body, something of that nature. It's a tool that they access directly. Next one is one where an intake clinic assistance tool where the person themselves as the end user is not really going to be the one using the app. It's maybe a clinic worker, an intake person. This could be a lawyer. This could be a volunteer. We see all flavors. Where it's designed basically to speed up their process, whereas the self-help tool is usually designed for people before they actually come to the clinic. And then finally, we have an interesting flavor. We don't see too many of these, but the ones we do I think are really cool, really interesting, the advocacy or adjudicative pieces. These are tools that are designed to help make a very complex piece of law simpler for either an adjudicating body or as more of an advocacy piece for what the law should look like. And we have a really interesting app that we're going to kind of demo called Midas, which talks about the tangle of confusing and sometimes conflicting decisions that make up veterans' benefit law. So just going through these really quickly, for the self-help tools, as I said before, the client is the person who's going to be using the application. So you have to think about what does the client know, what are they going to understand, especially with low-income workers, you have to think about phrasing questions. You have to think about what kind of answers they would reasonably be able to give, what kind of information they'd have on hand, and all while you're doing that, educate them on the applicable law. For triage systems, it's important to let them know why they may or may not qualify for your assistance. In addition to any kind of legal issues, you also want to let them know particularly why they can or can't benefit from your organization. For clinic assist tools, it's your intake worker, which means you probably don't have to be quite as careful with your language, and you can also include as given some legal knowledge sometimes if you have lawyers who are going to be administrating this app. It's a lot more about making your process a little more efficient and standardized, especially, for instance, if you have intake workers like volunteers who you may have a large revolving cast. It's really hard to kind of keep these things consistent, and it helps make training and individual sessions a little more consistent. And finally, then we have the advocacy and adjudicative pieces. On the adjudicative side, we have where the judge or decision maker will be the user. We see these in some of the regulatory agency applications that we make, where you're either translating a very complex area of law or you are working to make something that could produce very inconsistent outcomes a little easier. What we see a little more often in this flavor is the advocacy side, where you are actually contracting with an organization or a particular person who is dealing with something that doesn't have an answer yet because there just isn't the controlling appellate decisions out there. VA benefits law is a very big example of this. There are a lot of local, small-level, non-binding kind of decisions out there that kind of conflict and have a lot of issues. There isn't a lot of clear guidance from up above just because so few decisions make it that high. So we have one application which I'll show that offers an approach and is a little bit of taking the existing law, but it's also going to start trying to put the law into something that makes a little more sense and offers solutions. So we call this a little dynamic law review article because the MIDAS application, which we'll show, was meant to, it basically took a 300-page article and made it a dynamic program that somebody could walk through, and it's a lot clearer and it's a lot easier than reading 300 pages. It's a lot more accessible to people. So I think it's a really interesting way of making a point about how things can be done. So now to talk about the applications we'll be showing ones from each of these sectors. So for the kind of self-help, well, self-help / clinic assist, we have the OAH and the EJC. More often we sometimes see a blending of these categories. So the OAH is the Office of Administrative Hearings, and we created an application, this was last semester, to help people, this is both employers and employees, who are appealing an unemployment benefits decision. So these are all people that are going before an adjudicative body that need help. So there's no kind of triage kicking them out. It's we have to help you no matter what. And I'm going to work through a legal question. The second one is the Employment Justice Center, a pro bono organization here in DC, helping low-income workers with potential wage theft claims, whether they have minimum wage issues or overtime in the DC, Maryland, or Virginia area. It is designed so that it could be self-help, but the way that they've implemented, which I'll talk a little bit when we get into the app, is that they have used it for their clinic and tried to make that, and they're using it now, testing it to make their clinic intake sessions a lot more efficient. And then finally, we have the MIDAS app, the Military Impact of Discharge Assessment System. It was originally designed to be an adjudicative piece that would go before judges, and that it would help them understand how the various different benefits offered for veterans could help them, how they could be applied to veterans with potentially confusing discharge situations. Generally, anything, honorable discharge, you get access to all of the various benefits, but there are a lot of different categories between honorable and dishonorable where the line is blurred. And even for dishonorable discharges, there are some questions there. So this app seeks to kind of help that. The problem is that there isn't really the law there to draw and to make a little clearer. So it ends up becoming a little more of an advocacy piece of this is where we think it should be. And this is what makes the most sense based on certain judges' approaches. So with that, I'm going to get into the actual applications here. So here we have the Employment Justice Center, which is actually I think the first one we talked about was OAH, so I'll do that one first. So all of these are using Yoda Logic, They generally appear as an online link, so people can access them publicly. And if you have this URL right here, you can access it right now. They all come in as questionnaires. So you'll start with basic, disclaimer, information language, and then we get into the actual hearing coach itself. This application talks about, helps either employers or employees, and helps whether or not they are appealing a decision or they're defending against their opponent's appeal. And that will change the burden of proof that goes into the analysis. It changes the language, so how we ask questions. Is it targeting for employers or employees? So we'll say employer defending. And it just goes through and asks questions. And the organization, the great thing about Neurologic, and I think some of the other tools out there are starting to get this level of complexity, is the ability to efficiently create a program. So instead of having ask first question, then ask second question, then ask third question every single time, it will conditionally ask questions based on the information it's receiving. So it's thinking, how do I get most efficiently to the answer? And for triage applications, which we'll show in a second with the EJC, this is really great because if there are particular things that will automatically disqualify people, you want to get those out right away so that you haven't wasted somebody's time going, 8 or 9 questions into an app when one could have shown that they just, they didn't meet your income eligibility requirements, for instance, or something along those lines. So the application can determine the order of questions to think of the most efficient way to kick somebody out of the app. So we'll just answer some more of these questions, and it's going to ask basically the nature of the employees, how their employment terminated. And if there's particular questions about that, we can ask and put in additional information. The point is to inform the end user along the way why we're asking these questions, what do they mean, and then ultimately with their output, how best they can help you. So here we have information about whether the employee was fired or quit. That changes a lot of it. About how things actually turn out. We have a whole bunch of potential reasons as to why somebody could have been fired. For say they were dishonest, they were drunk, unauthorized personal activities, and they used profane language. This is somebody who really should have been fired. So we get a little interim message that might give some kind of intermediary conclusion, letting people know what their answers mean thus far. Then we'll have follow-up questions where it's asking a little more specific details about things that might change how particular answers affect the final outcome. So we'll just answer randomly here. It doesn't matter too much. One thing to note is we also have the option of emailing reports to people. We can also email reports to the actual client. They can start building up information for particular people before they've actually ever stepped foot. And if we say yes, then we can get their email address and so on and so forth. And with all of these apps, what we end up with is a nice little report, something that says you have a strong case, you have a medium case, or a poor case, difficult case, however the language you want to phrase it. In this particular one, we're really phrasing it for the user, for the actual person who's going to go through the appeal. So the whole point is education. So we give them a basic overview, we talk about the burden of proof, and then we talk about specific issues and kind of break it down a little. So for each of the different specific issues under their claim, for reasons they were, the person was fired, we'll talk categorically about things that kind of help their case and things that might not help their case. We even get little visuals, let them know. So overall, it says we have a strong case, and if we kind of look down, we have something here that's a little mitigated. We have a strong case right here, intoxication or use of controlled substances. That's usually considered gross misconduct and is a valid reason for firing somebody. We have some ones that are kind of borderline. It's really situation specific. And then finally, I think probably most importantly is the next steps. We tell them what to do now that they've taken this application, they have an answer. And that is the best way how you take an app to fit it into your process. So if you're doing this before any kind of triage, any kind of assessment, then the next step would be come to our clinic and bring this information with you or bring these documents. If it's built for a clinic intake worker, then maybe provide a specific report that the intake worker could then take to a legal expert, or something along those lines. So we're going to get there with the minimum wage overtime app. So this is the one for the Employment Justice Center. This was originally designed to be something more along the lines of the OAH in terms of an end-user helpful app, and I think it's still kind of phrased such that it could be. But the way they tend to employ it is to use it within their intake sessions. So during the design process, this is an app I personally worked on, the Employment Justice Center has intake sessions where they will have an intake worker sit down with particular individuals that have a wage, some kind of problem, and they go beyond, I think, just wage theft. That tends to be a very large problem they face. And they just basically get that person's life story. They ask a series of questions. They have a form of things they need to get. The person's also talking to them. This process tends to take about an hour. If they have a wage theft problem, the idea is that an application like this helps guide the narrative so that instead of getting their life story, you're getting the information they need, but it's still structured in a way that is making sense of their problem while still efficiently getting to the root of it quickly, while only getting the necessary issues. So do I have one I did? And here's one I did earlier. So we go through the questions, and basically it's going to ask them a series of questions about a combination of legal questions of whether or not they worked sufficient hours or in a certain job that may exclude minimum wage or overtime requirements, but also ask questions that get to the triage element of it, such as their income. If they're over the income eligibility limits, for instance, or if they live outside of the Maryland, D.C., Virginia area, things that don't exclude legally a claim, but exclude the EJC's ability to help them. And we'll tend to ask those questions first, though, because those are automatic kick-out. We have a report. It ends here. We'll have an overview for the minimum wage and the overtime, separate overviews because these are separate issues. And then we'll give them we'll even walk them through the math. So it's a very similar kind of output, and then we'll have finally the next steps to kind of figure out what to do for people that are going before the clinic. Come to our clinic. For people who are actually in the clinic, they can take this to the lawyer, look it quick over, make sure there aren't any other additional issues they need to consider, and then they can finally take it back to the client. The final app we're going to look at really quickly here is MIDAS. This is the Military Impacted Discharge Assessment System. This is the one that is, actually as noted above, still in development. We're still working on getting this completely ready. It's a very complex area of the law. So it's going to start asking questions about service members, and this is generally designed for a adjudicative body. So when we give descriptions, rather than try and educate a user, we're trying to point to specific laws. We're trying to help an adjudicating body determine what these things mean, rather than already have an answer, already have law about what is considered a subversive activity. That's something the judge is probably going to be determining whether certain facts meet that. So they're thinking about that ahead of time. We then have them actually answer it based on whatever their current opinion is. Some of these are like fact-based, such as what type of discharge should they get. There will be documents that will say that, and other fact-based issues. And we just kind of do some of these default answers here. Get to the end really quick. What it will do is, should have had one of these queued up earlier. My God, there are a lot of these. There we go. So what we end up with is a report that will talk very specifically about certain areas and how they think this should apply. And right now it's phrased how things do apply. It's very conservative. But what it is doing here is taking the various questions that we asked and combining the answers from the questions along with certain logic. Sometimes it's very simple with if-then. Sometimes it's a little more complex depending on what the law states. Sometimes things are a little fuzzier. And what it results with here are different conclusions for particular apps. And what you get here is some VA benefits and lists the different benefits they get. For other conclusions, sometimes it will say you have access to these benefits, you don't have access to these other ones, you may or may not, so it reaches kind of fuzzy conclusions. Those are for areas we don't really know what the answer is. And for those areas, it will then even offer a suggestion. And that's a piece that's actually still being worked on a little. So those are just some of the many applications we've worked on now. I think this program is entering its 4th year at Georgetown Law. So we're always, and I know TUNE is always excited to work with more organizations. So if you're ever interested, I think we can, if they have our information, that can be forwarded to you, or we can we can make that publicly available. Panelists is always accepting applications for new clients with interesting legal questions or legal problems that they may need for pro bono organizations. So I think that's all from me. Julian, should I transfer back to you? Oh, no, Adam is. So without further ado,
thanks, Zach. We just had a couple of questions in the chat box. Zach, one was from Jamila, who wondered whether any of the tools that you're involved with, or perhaps at Georgetown more generally, are available in languages other than English, the kind of end-user litigant-facing ones.
So whether the tools themselves are accessed in other languages, that's something I'm not personally familiar with. I think Access to Justice might have other language components in the tool itself, and I believe Neotologic, if it doesn't already have that capability of building a tool in another language, they might be working on it. In terms of the final display piece, however, in terms of like an application being in another language, that is absolutely doable. I know Neotologic supports a number of languages, but for the most part, any kind of text object that you see is something that can be edited in a very basic text editor that can be written in any language you want. We've actually had a number of requests to convert programs into other languages, and that's a challenge that we're going to be working on, I think, this next semester with one app, hopefully, of creating an app kind of concurrently in multiple languages.
Right.
But that's absolutely possible in at least some of these.
Great. Okay.
So one of the other questions there was on what's going on the back end. Can we collect all of that data and then send it to a case management system via an API? Is it in an easily accessible database or a proprietary data structure? What does that look like?
So Neotologic has the capacity to collate data and send it and interface with other programs. It's a little more complicated than what we tend to do in the context of Georgetown Law's classes. There is, however, one issue outside of the technical component to that we tend to strongly advise against doing that for our systems, and that is the issue of confidentiality. It becomes, at the point where you're collecting users' data and collating it, it becomes a little more of an issue in terms of protection of that information and what it's being used for. For most of the applications that, for instance, the ones we've shown you, rather than collating data, we're helping somebody right there on the spot, and then that data is wiped. And that's that person's data just for them, which they can choose to do with as they will, or we can send individual snippets of that data, a report, for instance, for that person to an email outbox so that they have that person's information, the organization has that person's information.
And then if the person needed to fill out 7 or 8 different forms over the course of a year, they would basically be starting from scratch again with all the information, entering it into the system?
For this type of, for Neotologic, if they had, so for the types of applications we've made, if they had 7 or 8 issues, they would probably be sufficiently different enough that they would have to enter their information again. For the most part, though, they're not entering a lot of the same kind of information, like their name or, basics, their age. Those things tend not to come up quite as much. It's usually questions really relating to the nature of their legal problem, which I imagine would change. If they're getting into the same legal issue 7 or 8 times, I think there's perhaps a deeper problem. They might have some deeper problems than having to enter something over and over again.
And what is the cost in working with Neotologic?
Sorry?
To the organization, what is the cost in cost to use the system?
So Neotologic is still a relatively new tool. So that is something that is highly contextual depending on the project. For pro bono organizations, Neotologic has worked out special deals through Georgetown Law, and they're, I believe, working on creating an exportable class so that other law schools will have this ability as well, that they don't charge anything to the pro bono organizations that go through this program, I think for at least 1 year, and then afterwards they they work closely with the organization to figure out a better long-term situation. For the most part, I think that's usually meant free hosting elsewhere. At the point where you're not really collecting data, you're just having an app that's getting used by people, it's not too much of a strain on Neota Logic. It's at the point where you are collecting a database and maintaining something that's increasingly growing in space, and also where you have a complex area of law that might be constantly changing, that requires some updating of the application. That's when Neota's resources get implicated a little more heavily, and then they have to have a little more of a discussion. For the apps that we've shown, for instance, there's been no costs to people who've asked these.
I do know, Brian, that some of the one TIG-funded project I'm aware of will pay, I think, a quite heavily discounted license fee for the software. I'm not sure what arrangements other TIG projects have that are using Neota, but can certainly put folks in touch with a contact there if they're interested in learning more.
Okay, because the long-term cost is definitely something a lot of people are curious about. So whatever can be done to make that more transparent will encourage people to decide the long-term cost-benefit analysis of using it.
Yeah,
thank you.
I think that's a great point. And I just wanted to make sure folks also saw Jessica Frank's comment in the chat box regarding A2J authors support for guided interviews in multiple languages, and she mentioned that it allows for Spanish, French, English, Korean, and simplified Chinese to create guided interviews using A2J author in those languages. Great. All right. Thank you, Zach. So we will move on to Adam and Donna.
Hey, thanks, Liz. My name is Adam Friedl from Probono Net, and I'm joined by Donna Dougherty from JASA Legal Services for the Elderly. And we're going to spend a few minutes talking about a project that we recently did with Georgetown Law School and Zach's program to create an app that we call the DEN, or the Debt and Eviction Navigator. And I'll take just a minute and sort of offer some context for why we decided to do this and how it came about, and then I'll ask Donna to explain a little more the details of how it works. Here in New York, for the last few years, there has been a task force convened by the Chief Judge, and it studies different ways to expand access to legal services in New York State. It focuses on a number of different things, including technology and various other issues. One of the committees, however, is dedicated to the use of non-lawyers. And some states are definitely ahead of New York in exploring how to leverage non-lawyers to increase access to justice, but we are trying to advance as quickly as we can. And there was a proposal that we would use social workers who are involved with many potential legal services clients to help screen them for legal issues and deploy legal resources most effectively. And so we were able to partner with Georgetown Law. The idea was to create a screening tool that would allow non-lawyers to work with these clients that they're already seeing. And Donna, maybe you want to talk a little bit more about JASA's programs in particular and how this would work? Hello, Donna?
Donna, just a reminder, *6 to unmute if you're on the line.
Okay. Well, if I can go ahead and I can cover it, and Donna, if you come in, feel free to cut me off. So at JASA, they run a legal services program for elderly clients, and many of their social workers do in-home visits to clients who are effectively homebound. For obvious reasons, these clients find it very difficult to access legal services, or in many cases to even properly be able to realize when they have a potential legal issue. So the idea behind the app is that social workers making these visits can pull out a computer or a tablet and go through the app to do a very basic interview that has been designed by legal experts, content experts, to help diagnose whether someone has a particular legal issue And if so, to suggest next steps about how to handle it.
Adam?
Yeah, hey Donna.
Ah, there we are. I apologize.
Hey.
I kept hitting *6 without anything. So, let me jump in. You did an excellent job, Adam. You can come work for me. So we have this large social service agency throughout the city of New York, which deals with individuals 60 and older and has a large number of social workers who go out to people's homes regularly as part of their contact with their clients. And what they were seeing, and they didn't know how to handle, was, people would say, oh, I may have an issue, I may have a problem, and they would have a hard time accessing the courts, those clients, because of physical impairments, maybe mental impairments, or just it's daunting to try to get to the courts in New York. And as part of JASA services, we have a legal service component for Queens, but again, I don't normally reach those clients unless they reach out to us in our intake. And so what we're doing is the social workers on their regular meetings, which are once a month, and we've seen now over 200 clients since this has started, are using the app to go through as part of their regular meeting with their client a series of questions. And those questions take you, as we'll show, from one piece to another, and will alert the social worker and the client whether or not they have a housing issue which may need to be taken care of, or in fact if they have a housing case where more urgent, something more urgent needs to be done, including contacting a legal services office. In addition, as part of the project, the courts here in Queens have agreed that if the social worker going through these series of questions, if in fact they need to take some sort of legal action like answering or like putting in papers to vacate a default judgment, that through the laptop they can connect to the court, and the court will work through with them to accept the legal documents so that the person has access to the courts and doesn't default. So it's this combination of using this app so that the social workers know what they need to do next, and working with the courts to work with us through technology.
Yeah, that is exactly right. And as we see on the slide here, future steps include eventually incorporating e-filing. We hope to make this more of a fluid process that would lead from diagnosis of a legal problem to walking a client through the issues to helping them actually file the required papers if it's a relatively straightforward case. I think now we'll just take a minute and demonstrate for folks a little bit about how it works. It's relatively straightforward. Our social workers are going to be screening for 2 issues, housing and consumer debt in this case. So we just click along, fill out some basic questions, etc., and I won't make you sit through the whole thing. But when you get to the housing section here, you would hit continue and have a list of questions to screen for different issues. Housing law in New York City particularly is extremely complex. There are a lot of different types of subsidies that one has to be aware of. So the workers using this tool have the benefit of a legal expert's sort of take on how to conduct a screening interview. In this case, Donna Dougherty, who is one of the leading housing law experts in New York City, I would say.
Well.
And
I will say one of the things, Adam, if I can jump in, that was very important to the social workers, in which this app does, and when you work on this type of a tool, and this is the first time I've worked on one, is that the social workers were of all types of technology advanced, and some who had never been on a laptop before and found this very daunting. So one of the things was to make sure that the questioning and the ease of the program so that they really very quickly got used to it and it became part of their natural process. And that seems to have worked beautifully with the social workers based on the feedback we're getting.
Yeah, and I would say that I would add that it is very neotologic the way that it's set up. It's very user-friendly, and I think it's very intuitive. This is the screen that we're looking at now is essentially a printout of the results of our screening interview. And so for our two issues, landlord-tenant and consumer debt, it has given us a series of conclusions based on the client's answers to the questions. And it's also given us a series of links that we can use to pursue next steps, possibly seek a referral based on the information that it's recommended. So here, for example, it's suggesting that we may need to create a document telling a judge why we should not be evicted, or we call this an order to show cause. And by clicking here, we go directly to that program. Let's see. Similarly, we can also let me just go back real quick. We can also, if we have consumer debt issues, be taken to a page like this on Law Help New York, which will show us a bunch of different resources that may be applicable, as well as an informational video and do-it-yourself forms on A to J or Law Help Interactive. So that's a really brief overview. The program at Georgetown is great. They're really fantastic to work with. Zach has been extremely helpful to us. And using neotologic, as I said, has been really very fun and very easy to do. So with that, I'm going to turn it over to Mark Lauritsen from Capstone. And Mark, please take it away.
Great. Great. Thanks, Adam and Donna. And I just wanted to highlight one thing before we transition to Mark. One reason I was excited about showcasing this example during this training was, I think, regardless of what technology you use, I think these kinds of systems have a lot of potential in equipping non-traditional justice partners or non-lawyers like social workers or nurses or others in helping to do this kind of frontline legal screening. So here in the Bay Area where I'm based, there are a couple of programs that are collaborating on a web-based app to allow nurses to do legal screening in the context of nurses and social workers to do legal screening in the context of medical legal partnership. So I'm not sure what platform that's developed in, but I think that's another space where these kinds of tools have a lot of potential, again, to engage non-attorneys and perhaps non-traditional justice partners. So keep the questions and comments coming. We'll keep an eye on the chat box. There's some good discussion there. But in the meantime, we will transition to Mark, who's going to take us a little bit into some, I think, really exciting and cutting-edge research on tools and techniques to help people understand and make better decisions. So thanks, Mark.
Thank you, Liz. I just want to confirm that I'm audible.
You are, and we can see your screen.
Excellent. Life is good. Hi, everybody. Mark Lauritsen. I've been involved in expert systems and document assembly for about 30 years, and it's very gratifying to see this finally, over the last decade, becoming really getting good traction in the legal aid context, especially with tools like Law Help Interactive and ICANN and other initiatives. And the neotologic stuff at Georgetown and elsewhere is also very encouraging. But I've had the nagging sense for about the last 12 years that we're missing part of what people need in these kinds of tools, which is support for making decisions that do not lend themselves to being expressed via rules. So my premise is that supporting choice, either by advocates or self-helpers, requires technologies beyond databases and document automation and guided interviews and expert systems. So that's what I want to talk about. Databases, of course, are fundamental and great for storing and finding, searching information, doing reports and statistics, things of that nature. They can deal with not just text and numbers, but rich media like images, sounds, and video. Document assembly is incredibly powerful, and we're now talking in terms of 500,000 assemblies happening on Law Help Interactive every year. So we're starting to make a dent. They can do interactive advising and guidance, gather information dynamically, as Zach said, by branching to go more deeply when necessary, and to generate very rich documents either as Word documents or PDFs or other formats. We now have A to J Author as a tool for creating very consumer-friendly guided interviews that go beyond the tools in Hot Docs and Rapid Docs and other document automation technologies that can provide a very rich experience with audio, video, and images to make the whole process much more accessible, and then yield out the back end a package of data that can be used for intake or for triage or for document production. And expert systems have the distinctive power of being able to express knowledge non-procedurally, so-called declarative knowledge representations that can then draw upon rules engines, inference engines to do backward and forward chaining and other forms of reasoning. They also can explain their reasoning, which most of the other tools we've seen do not do without a lot of extra work. And so it's a very powerful tool, as we've seen, for individualized guidance and for constructing reports and other kinds of documents. But I don't think, when it comes to actually making a true choice, that these tools generally have the power and the facilities we need. So part of that is because a choice, when you're selecting among options that differ in ways you care about, they involve competing values and alternative evaluative perspectives. Choice is not a matter of algorithms or rule application. You can't generally look up or compute the answer to a choice. If you could, it's not really a choice. So we face choices throughout the whole landscape of law, both on the client and self-helper side and on the professional advocate side. In legal services, there are choices like which cases do we accept? What service do we offer to the clients we do accept? What are the various choices in litigation or in transactional practice? What claims do we make? What arguments do we emphasize? How do we settle? What settlements are acceptable or not? And then from the administrative side, what technologies do we adopt? What priorities do we pursue in our office? Or for an entity like the Legal Services Corporation, how do we prioritize our spend on technology and legal aid? So a quick example in the triage context, where someone is deciding which services and resources to make available to a recipient, you're balancing a variety of things. You're balancing the circumstances of the recipient, of course, what's best for them, what's at stake, how likely are they to succeed given a certain resource application, how capable they are of self-help. On the provider side, you have questions of availability and priorities and the circumstances of the provider. And then you have systemic interests and values at play that you all need to kind of balance. And this is happening in the context of great demand exceeding the resources, very complex circumstances on both the provider and the recipient side, and lots of different genuinely held views about what works best. Should we put money into self-help and put money into representation? And when it comes to a specific case, you can imagine it's kind of like a balancing. You're deciding whether a presenting tenant who's being evicted should be given an attorney or pointed to an online document assembly solution. And you have various considerations in play that might tip the scale one way or the other. If you represent somebody, presumably they're going to have a better chance of winning. There might be law reform opportunities. But when you're thinking systemically, if this person's capable of representing themselves, perhaps an online solution is going to be superior, all things considered. So we're constantly doing this kind of balancing on the one hand, on the other hand, trying to decide, make an informed judgment about what we should be doing. The problem is most decisions are not on the one hand or on the other hand, they're on many hands. We've got too many hands to manage in this balancing two-pan scale metaphor. We've got more than two options. We've got lots of considerations that differ in terms of their relative importance. And we have people disagreeing about the relative goodness of the options on those factors and their relative importance. So the question is, can we support this through technology? Again, where we're not dealing with rules per se. And of course, paper is a good start. This is a little grid we made up back in Project Pericles at Harvard in the mid-'80s when we were trying to decide on on a word processing tool. And I think we've all been through this kind of thing when you're buying a car or a camera. You've got kind of a consumer's report style grid of factors, considerations, and then assessments of various alternative options. And of course, it's not just a matter of how well a particular option does on a factor or a feature, but how important is that to me? How desirable is that outcome? In modern days, we moved to whiteboards and tools like Microsoft Word to make better looking tables. Of course, with a whiteboard, if you don't remember to take a picture of it, you come back to the next meeting and the whiteboard is gone. So you might put it into a Word table. I did this for choosing a case management program for a law school clinic. The next natural step is spreadsheets. And we had to decide about 10 years ago which technology to emphasize for document assembly on what became LawHelp Interactive. And we went through an evaluative process looking at different alternatives, assessing them about various characteristics we cared about, and built this as an example of how to think about weighting the various considerations. This is not the real data. But I felt we needed a totally new tool for this. And so for the last 10 years or so, I've been focusing on this metaphor of choice boxing, which is seeing choices as essentially a geometrical exercise, where you've got really a three-dimensional spreadsheet of columns consisting of things you're considering as alternatives, rows being considerations or desiderata or factors that differentiate those considerations, and then the layers here are the evaluative perspectives. So say you're choosing a case management system. ACE, ACME, and APEX are the finalists. And the key features or characteristics you care about are the overall feature set, the interface, quality, and the ease of learning. And we've got 2 or more people involved in doing the assessment. They've got different views and opinions, both about the relative goodness of the options and the relative importance of features, so they can express them in their own little cell. And then you can represent this through some form of interactive visualization. So as far as I know, this does not exist apart from some prototypes we've built, but it's a way in which you can represent the relative goodness of options and the relative importance of factors geometrically, and then total them up. So kind of when you melt down these little nuggets of goodness into these boxes, you can say, well, ACE really seems to win out, all things considered, at least from Jane's perspective. Maybe John feels differently, and then how do we combine the two? And you can imagine this getting much richer with, in this case, I'm showing an example of a decision between potential funding for mobile and document assembly and other things with different perspectives in terms of how they empower self-help or empower staff or promote private bar involvement, etc. So I'll close with an example of how this can be used. The LSC did a pair of summits on technology and its use and funding last year. And in between, we had come up with some 50 different potential initiatives and a couple different criteria, things that we thought were important in judging these initiatives. And the question was, how do you do an organized process to prioritize those considerations and those activities? So they brought together 50 or 60 judges and law professors and legal aid directors and staff attorneys, librarians, technologists, and brainstormed. And the question is, how do you massage that? How do you funnel that into an actionable plan? They engaged this startup I'm working with called All About Choice to put a choice boxing system in the hands of this community. And each person was given the opportunity, first of all, to cull through the activities and the objectives to come down to a more manageable set of about 10 each. And then for each activity, like for instance funding expert system development, assess it against criteria like how much does it help us build resources? How much does it improve provider effectiveness? Does it reduce barriers? Does it stimulate innovation? So a given person would move with these sliders to indicate how they thought this particular initiative would advance these different agendas. Once they've done that for a particular thing, they could do it for other activities, and then see a summary in the form of this choice box idea, where again the relative width of these objects represents the person's assessment of how well it does this particular objective, and the height represents the importance of that factor in terms of improving 100% access to justice. And then you can do some simple math to total these up. So this particular person ends up thinking the document assembly for self-helpers happens to be the most efficacious across all these considerations. So once you've got one person doing that, imagine 32 or 35 have done this. You've got this virtual three-dimensional data structure of opinions and views from which you can harvest, I think, a reasonably respectable sense of the wisdom of the crowd. What, across the community of all these different viewpoints, across all their assessments on these objectives, what do they think has the most bang for the buck for LSC? And this, in fact, became a tool to use to decide on the 5 or 6 priorities: document assembly, triage, mobile, remote service, and expert systems and checklists. So that's my quick presentation. That's an example of applying this technique for a large group deliberating about policy. But I think very similar tools can be used for individuals deciding on legal choices or organizations choosing organizational technology decisions. And my last slide, which you can get from the collection, is just links to some articles about this. And I recently created a very simple hot docs example of this that's available on Law Help Interactive if you want to play with the idea.
Great. Thank you so much, Mark. And we'll circulate a couple of the articles that Mark referenced, and I think are linked here. Make sure that those are circulated with the slides after this presentation so folks have a chance to take a closer look at the research that Mark has done as well. We're just at the hour, but I think we'll, just with the size of this group, we'll try to hang on for a few more minutes and take some last questions here. I wanted to just go back to a question that David Kessler had that I think was directed to some of the projects that are online now, and whether there are particular outcomes, either Zach or Adam or Donna, in the efforts that you've been involved with, where you're seeing these tools, seeing how well they're used by clients or advocates, or noticeably reducing kind of intake workload. David, your question also ties into, I think, in some ways, a slide deck from a workshop at the Equal Justice Conference that I just circulated through the chat box that talks about some of the more intake-oriented projects that are live or have gone live this spring, including one in Massachusetts, and there may be reference to one in Illinois there as well that might have some information that would be of interest to you too. But for Zach or Adam and Donna, are there any kind of particular, as you've started to see these tools being used, any particular interesting outcomes from a client or advocate perspective that you'd want to highlight?
Zach here. So I have one that springs right to mind, and that is the wage theft application. This is one that's currently, it's been revamped a little and is back in testing, but generally we have something approaching harder metrics with that than we did with a lot of the others. So as I mentioned during my presentation, the intake session for the individuals was usually about an hour, and that was most of the clinic time they would have set up. So one intake worker was really going to be dedicated to one person, maybe one or two people for the entire time the clinic was open. Because the basic intake session would take an hour, and then there would probably be a half hour, another hour of follow-up based on follow-up questions a lawyer might have. So we were looking at probably about 2 hours of total time when we included the application into the intake process for those users that had, those individuals that had a wage theft problem. The basic crux of their legal issue, the kind of, without too much of specific details, we just got just generally whether or not they had an issue and whether or not they were right for EJC, that took about 10 minutes. For general intake times, you wouldn't be able to necessarily get that automatic kickout information or that automatic eligibility information in the first 10 minutes of that hour and a half before, because you were getting this kind of free flow narrative, or you were filling out this big long form where you always ask the same questions and the people didn't necessarily understand them. So we saw incredible time jumps. So we're still awaiting some kind of more formal reporting on how this is going to shake out, but it looks like individual intake users might be able to help, hopefully once this is kind of fully running, up to 2 or 3 times what they were able to before. And that's generally the hope for us for all of our kind of intake triage-related systems, where it'll go from something a little less structured and a little more time-consuming to something much, much more ordered, much quicker, getting resolution, some kind of basic resolution faster so we can get to the crux of their specific factual situation, and then just more people?
From our perspective, we started this we've recently just started it, so some of this, it's anecdotal right now, but two or three of the things that we've recognized right away is that we see people at an earlier intervention stage, and for our resources, for our legal resources, that's very important, because the sooner we get someone, the easier it is for us to resolve their legal problem, and so that is a time factor for us and a resource issue for us. The other is that the social workers, this is a screen, so we have a screen done, so rather than if a social worker called me up, which is the way it used to go in the past, and we'd sort of have this three-way conversation, which took time for the lawyers, we now have a screen, and there's been a certain amount of information that we've gotten directly from the app. And then the third thing is the social workers are becoming much more efficient and educated in identifying problems with their clients as they've started to do this. So again, that from a time efficiency and resources is helpful to us because they're becoming much, much better at identifying issues.
Terrific. Thank you. Okay. Well, thank you again to our panel, and thank you so much to all of our attendees for joining today. This is, I think, just a small sample of some of the exciting projects that are happening in the community, and hopefully we'll have a chance to share out more in other NTAP webinars and conferences later this year. We've included the panelist contact info on the slide deck, and would encourage folks to reach out to them directly with any follow-up questions. And also please take our survey, which we'll send through the chat box in a moment, to provide feedback on this training and what we can do better on future trainings. So thanks again, everybody, and have a great day.
Thank you, everybody, for coming out. I greatly appreciate it. Just a reminder that there is a follow-up on online intake in about a month, and all of our trainings are posted over at the LSNTAP website.